While two Law and Justice MPs have been locked up in prison for 2 years, there is a continuing discussion in the Polish parliament and media about the legality of this move. If this is contrary to the law, politicians are raising questions about the possibility of the Polish parliament working in a situation when the authorities are preventing two MPs from exercising their mandates. According to the constitution, the Sejm has 460 deputies, while 458 are admitted to the proceedings. More information on this subject was prepared by editor Holdinska.
Marszałek Sejmu wygasza mandaty.
The Speaker of the Sejm is still waiting for correspondence from the National Electoral Commission and complete data from the Supreme Court regarding the expiry of the parliamentary mandates of Mariusz Kamiński and Maciej Wąsik. Any act adopted by an incomplete panel may be appealed to the Constitutional Tribunal. In my opinion, they have parliamentary mandates because the audit chamber overturned the decisions of the Speaker of the Sejm. However, Speaker Hołownia believes that the two rulings of the Labour chamber of the Supreme Court effectively ended the mandates of the MPs. Firstly, the second ruling of the Labour chamber of the Supreme Court applies only to MP Kamiński. And secondly, it is invalid because there was a previous ruling in this case. We have Article 7 of the Constitution, the so-called principle of legalism. Every public authority should act within the limits of the law. In the light of both the Constitution and the Electoral Code, it cannot be said that those parliamentarians are no longer MPs. Article 247, Section 1 of the Electoral Code states that the mandate of a deputy expires in certain cases. 1. Death of a deputy. 2. Losing the right to vote or not having it on election day. 3. Deprivation of mandate by a final judgment of the state tribunal. 4. Resignation from the mandate. 5. Holding a position or function on election day which, pursuant to the provisions of the Constitution of the Republic of Poland or laws, cannot be combined with the mandate of a Member of Parliament, subject to the provision. None of these cases include Mariusz Kamiński and Maciej Wąsik. An MP may lose his mandate, but all the conditions must be met. In this case, the loss of passive electoral rights resulting from a final conviction. In this case, we have a statement from the Control and Public Affairs Chamber of the Supreme Court that both MPs retain their mandates. The decision of the Speaker of the Sejm, Szymon Hołownia, regarding the expiry of the mandate of Law and Justice MP Mariusz Kamiński was published in Monitor Polski. The National Electoral Commission did not send us any correspondence indicating the person who will succeed Mr. Kamiński as an MP. Law and Justice MPs alerted the prosecutor's office, considering the conduct of the Speaker of the Sejm illegal. The decision of Speaker Hołownia was illegal because these MPs were acquitted. We are dealing with a violation of the law by the Speaker of the Sejm because he baselessly refuses to recognize the judgments of the Supreme Court. The matter is explained in detail by Professor Anna Łabno, a constitutionalist. The MPs appealed against the decision of the Speaker of the Sejm and the Supreme Court accepted their arguments. However, the Sejm deliberated today without Mariusz Kamiński and Maciej Wąsik. I am submitting a letter regarding enabling Mariusz Kamiński and Maciej Wąsik to exercise their parliamentary mandates. And I would also like to welcome the wives of both politicians, Barbara Kamińska and Roma Wąsik. Thank you for being with us. We are with you. Kamiński and Wąsik's places in the Sejm remained empty. The question also remains whether the Sejm can deliberate in such a situation. The Sejm is legal and everything operates in accordance with the law and the Constitution. Should the Sejm be in session when the two MPs are in prison? It should not be in session. What does the Speaker of the Sejm say about this? Will the Sejm deliberate in accordance with the Constitution? Of course. Here is a list of meetings from 2015 when there were no seats filled. The Constitution states that the Parliament consists of 460 members. If there are both 458 or 460 deputies, any adopted law may be challenged and referred to the Constitutional Tribunal. However, it is no secret that the courts question both the Court and the Constitutional Tribunal's rulings, questioning the correctness of the appointment of judges. The Court of the European Union has no power to determine who is a judge in Poland and who is not. Therefore, the question of compliance with the letter of the law is again related to politics.